number 129, People versus Dru Allard. Counsel?
I wish to reserve 3 minutes rebuttal, please. May it please the court, my name is Thomas Ross. I represent the appellant in this case. The appellate division's holding that the defendant preserved his 3030 speedy trial claim for appellate review was error. It was error because in the trial court, when the people asserted the 3034G exclusion for exceptional circumstances, the defendant did not do what was required under...
But counsel, just to help you, is that really what the appellate division said, that first decision? I read that as the appellate division saying you preserved your claim for, you asked for hearing, which they did. And they sent it back because they said under the CPL, you actually established enough to get a hearing. And that was preserved. And what troubles me here is the conflation of that issue with a substantive 3030 argument. Now, if they had lost on the hearing issue, then their arguments on what should have and should not have been excluded might have been unpreserved, as you say. But they did ask for a hearing. And under the statute, the appellate division said, you get a hearing, and that's what they sent it back for.
Well, I disagree that it's preserved on the hearing issue because the defendant asked for a hearing in his original motion papers, and it was just a general broad request for a hearing. When we came back with the 3034G exclusion, he was supposed to contest that on the facts in order to get a hearing. You don't get a hearing just for the asking.
You never made that argument that I see in your papers about the hearing not being preserved. Your argument, to me, always seems to go to you didn't preserve your arguments as against what the people were asserting were excusable delays. I haven't seen this argument. Is it in your papers?
The argument
about preserving the hearing request.
No, we didn't read the appellate division's decision as preserving his request for a hearing. We saw it as preserving the 3030 claim itself on the substantive issue. As far as the preservation for the hearing that you're bringing up, it was not preserved because in the defendant's original motion papers, he only asserted just a 6-month delay and then said, oh, if you don't summarily grant this, then we request a hearing. Once we came back with asserting our exclusions, for him to obtain a hearing, he had to contest our exclusions on the facts.
But we've never said that. This Court has never said in Lupron or all the other cases that in order to get a hearing, you have to file a reply. What we've said is, in order to preserve your arguments as to excludability, you have to file a reply, which are two very different things. And the appellate division seems to me, citing the CPL provisions and sending it back for a hearing, is saying you met your burden and you asked for a hearing, so you get one. And this defendant, wisely enough, only chose to go on that, not on the substantive 3030 grounds here. So that's what's here as preserved or unpreserved. And I don't see the argument anywhere in your papers that he didn't preserve the request for a hearing.
That's because, like I say, we didn't read the appellate division's orders as a request for hearing. The appellate division said,
the appellate division said, in opposition, the people failed to conclusively demonstrate with unquestionable documentary proof, which is a language from the CPL about hearings, that they satisfied the requirement. Accordingly, the matter must be remitted for hearing. So they never ruled on whether or not the substantive claims were raised or not in this decision. They just ruled on whether or not he was entitled to a hearing, which was what he was arguing and had argued below.
Even as far as he wasn't entitled to a hearing because he never contested factually our assertion of the 3034G. He never contested.
But where is that? That's not in the statute and it's not in our decisions. You know, usually in a hearing on a suppression motion, which is the same statute, I think, you file something saying it's coerced or whatever it is. The people come back and you have a hearing.
Well,
is that going to be the rule for suppression motions of statements too?
No, under 21045, ordinarily when you make a motion to dismiss, this is not just for 3034, but for any grounds, the defendant makes the motion and asserts any factual support for that, for the contentions. Then the people, in order to get a hearing, have to contest those facts to show that there's a dispute over the facts. And we can avoid a hearing by showing that there's, like they say, unquestionable documentary proof. But this was different here because the defendant here was not making the initial allegation of fact. We were. The defendant only alleged that there was more than 6 months of time which were ready. Then we, in the first instance, raised an allegation of facts by saying that the complainant was out of the country for for 1 month. Then it was up to the defendant to then contest our allegation of
I
fact.
couldn't get too excited about that because you weren't even right about that.
About the defendant being...
Yeah, the 5th or 6th ADA, whoever was now on that case said he's in Egypt, he was in Yemen. And I'm not even sure then that that's a good excuse. I mean, you can tell him to stay around or he's going to lose his case, right?
Well, but our contention is that it's unpreserved for appellate review because he didn't challenge that. He didn't say that an overseas vacation cannot be an exceptional circumstance, nor did they argue that we show due diligence.
Why wouldn't? I mean, you have to say that? You say the complainant's on vacation, he's up in Martha's Vineyard. That's an exceptional circumstance, and therefore his speedy trial claim goes.
But we're not here to determine the merits of the speedy trial issue, only to determine whether it was properly preserved or not. I mean, so it may seem entirely meritless, but did he preserve it? No, he didn't under the Beasley-Good-Luperon rule because, I mean, what happened here was the exact same thing that happened in Beasley, Good, and Luperon.
Can you dissemble like that? I guess I'm showing a little bias toward the defendant, but you went in and told an untruth to the court. You said he was going to Egypt. Now, I get it that you got the wrong country, but for God's sakes, can somebody pay some attention to the case and say, you know, we called our complaining witness, and he's going to Yemen for, you know, a valid reason, or instead of just somebody saying he's going to Egypt and it's not true?
Well, like I say, we're not here to determine whether that was a valid reason or not.
I know that, but what I'm saying is that you're saying it's not preserved. We can lie to the court. We can dissemble. We can make things up. But if they don't preserve it, we're okay.
Well,
I guess that's interest of justice in the appellate division. We shouldn't be looking at that.
Well, that's what we're hoping, that they do consider this in the interest of justice, because if they do consider the interest of justice, it should show the entire record, not just the 4G exclusion, but the 4B exclusion when we had an affirmation of actual engagement in which the defense counsel clearly requested an adjournment for the same 32-day period. It would show that there is no 3030 violation, and that's what we're really looking for, is to get this back into the appellate division to see if they would choose to consider the merits of this claim in the interest of justice. Like I say, I'm just talking about the merits here just as a matter of context. That's not what we're here to decide. We're only to decide whether the actual claim itself, not just whether there was a hearing, whether he preserved his claim for a hearing or not, but whether he actually preserved the 3030 claim itself, and that he did not do.
So we have this interplay between 2010-45 and our jurisprudence on preservation, right?
Yes.
Two different things.
Yes.
Right? And but do you agree that the people didn't meet their burden on this speedy trial motion under 210-45?
No, we did, because under 210-45, like I'm saying, ordinarily under 210, when the defendant makes the motion, it's the defendant that in the first instance makes an allegation of fact.
Well,
but
the
that's
defendant did make an allegation of
The
fact.
only
but you were beyond your time, and then your response, as I understand 210-45, is you have to come forward with, in order to avoid a hearing, you have to come forward with dispositive evidence showing that you exercised due diligence to get your complainant there, and that you weren't able to do that, right?
We didn't have to dispositively prove it at that point. We just had to assert it. We asserted the fact that the complainant was out of our control for that 1 month. Then it was up to the defendant under Step 3 of the Beasley Rule
Well, that's
to
the
then
Beasley
raise
rule.
an
I'm
allegation
talking
of
about
fact.
210-45 in the first instance.
Yes, but like I say, 210-45 doesn't really coordinate
It's
with the
not.
Beasley Rule, because after all, under the Beasley Rule, we do have the ultimate burden of showing that an exclusion applies, whereas in 210-45...
Excuse me, why can't 210-45 apply in the trial court when you're, when there's a question of whether the defendant is entitled to a hearing or not, but then when it's a question of whether you can appeal to this court, or under what circumstances to the appellate division can decide it, then we look at the Beasley factors.
Well, we look at like I said, the Beasley factors is only whether he preserved the merits of the 3030 claim, not whether he preserved whether he was entitled to a hearing. But even as far as whether he was entitled to a hearing, under 21045, as it is sort of illuminated by the Beasley rule, he didn't preserve his claim for a hearing because his request for a hearing was just in his initial motion papers.
How can we consider that when you didn't raise that?
Because he didn't argue that in the court below. He only argued that he had preserved the merits of the claim. He never talked about a hearing on appeal until the appellate division actually remitted it for the hearing. In fact, he didn't even argue that the 3030 claim on the merits was preserved or his request for a hearing was preserved. He only said that if you told the appellate division that if you find that this 3030 claim is unpreserved for appellate review, then it's ineffective assistance of counsel. That's all he argued as far as preservation in the appellate division.
Thank you, Counsel.
Okay.
Counsel, could you address that preservation point?
I beg your pardon, I'm going to leave that off. I'm so sorry. Can you ask that question again, please?
The preservation point that your co-counsel was just making on, you didn't raise this in the appellate division in terms of you were entitled to a hearing.
Everything that my colleague just argued is utterly moot, including the preservation question. And I would like to go back, Judge Garcia, and quote you from about 10 minutes ago. You asked my colleague, Bill Kasten, a question, and you said, what exactly are we being asked to review here? This court is being asked to review a non-final, intermediate interlocutory order. It is not appealable.
So there would never be an avenue of appeal from that? How could that ever be appealed then?
Sometimes there is no avenue of appeal from.
Well, how about the possibility that when the appellate division the second time around made a decision?
Yes, that is a
Okay.
final order.
Well, it implicitly then found preservation, did it not? It didn't say it was answering the question in the interest of justice.
It found preservation, but the preservation it found was what I argued after the hearing. That's what on the law was in the
But
final
how-
order.
Are we bound by, in other words, how, isn't the issue of preservation jurisdictional for us?
No,
So
it isn't. You are bound by CPL 45090. Only by statute are the people granted a right to appeal. And they have no right to appeal from the order directing a hearing any more than if this court, and forgive me, it's usually judges, not the lawyers who give hypotheticals, but if the court below had granted a hearing instead of deciding without a hearing, and the people thought that was wrong, no appeal would lay from that. And if there's no appeal from that, there's no appeal from the court's, the appellate division's order remanding for a hearing. The people's entire argument is moot. They do not argue, they do not assert that what I argued after the hearing was not the same as what I argued to the appellate division after the hearing. They do not argue that the Judge Chun's, the hearing court's ruling was incorrect. They're arguing something like objection overruled, a belated objection overruled. We're giving the defendant a hearing. It's not appealable. And yes, this court is limited.
Assume, there's a good argument, but assume it doesn't fly. Is this argument preserved in terms of the right to a hearing at the appellate division? Is that what you argue?
Defendant in his papers, as the people concede, met his initial burden with sworn allegations of fact.
At the appellate division, the first time around, did you argue that the error here was that he didn't get a hearing, or did you argue that it was wrong on the merits?
No, I argued that was wrong. I didn't say he didn't get a hearing, and I did argue ineffective assistance. That's not at issue here. The appellate division's jurisdiction, though, I've seen, fortunately, and not one of my cases, but I've seen them say, well, defense counsel missed an argument, but we see it and we're reversing on that. The appellate division is not limited to arguments made on appeal, and even though I did not explicitly ask for a hearing, in my initial brief to the appellate division, that did not foreclose the relief that the appellate division granted.
So you're saying that it was based on their interest of justice jurisdiction?
No, not at all. It was on the law because...
Just on the law.
Yes, because defense counsel below in his motion said the people have exceeded their statutory speedy trial time, dismissed the indictment. In the alternative, let's have a hearing to determine the facts. So it's based on that, and that is on the law, regardless of what I stated to the appellate division. That didn't render unpreserved. Preserved is based on what happens in the lower court, not based on what happens in the appellate division. This was fully preserved. And this case is not about, Your Honors, moving on to merits, although I don't think this court should even address the merits. As a matter of fact, I'll go to this in a few seconds, but I submit that this court's decision in this case should begin and end on this procedural hurdle that the people are attempting to make an end run around. They cannot get over that hurdle. They are not permitted to make this argument that they are making. Now, this case is not about Prado, it is not about Hampton, it is not about Beasley and Luperon and Good. This case is about CPL 210.45. And the pronouncements in CPL 210.45 are crystal clear. As the people concede, my client met his initial burden. The court may conduct a hearing if an allegation of fact is conclusively refuted by unquestionable documentary proof. The people tacitly, at least, concede that they did not do that. They make no assertion that they have done so. And not having done so, in subdivision 6, if the court doesn't dismiss the 3030 motion pursuant to that, it must conduct a hearing. And we all know what the word must mean. It's required. And so that's where the preservation as to the right to a hearing begins and ends in
The
CPL
only way I could
210.45.
see reading an argument, I think, into this statute that you need to have a reply is Section 3, right? Which says, after all the papers of both parties have been filed, and after all documentary evidence, if any, has been submitted, the court must consider the same for purposes of determining whether the motion is determinable without a hearing.
Sure,
Resolve
Your Honor.
questions.
And, you know, I threw in due diligence in my initial brief to the appellate division. I could have left that out, and the defendant still would have been entitled to that hearing. The appellate division didn't reach that. The appellate division just said the initial papers were enough, this is preserved, we're having a hearing. The appellate division didn't address any argument about due diligence. Those arguments I only made after we had the hearing on remittal. Now, secondly, also procedurally, once there's a hearing, the rightness of the decision, the correctness of the decision to order that hearing becomes moot. That's also unappealable. The people came back with nothing. There is, of course, no case law that says, well, the appellate division can just ignore what happened at the hearing because, you know, we really shouldn't have had a hearing. And so we will completely ignore all the facts adduced at that hearing. That's never been the law in this state. I anticipate it will not be the law after this court hands down a decision. My time's up. I ask this court to either affirm the decision of the appellate division, or even better, I think, to dismiss the people's appeal on procedural grounds. Thank you very much.
Mr. Ross?
The defendant alleges that we're appealing from the initial order, not the final order, but we are appealing from the final order. The final order, the appellate division denied on the law the merits of the 3030 claim, which shows that the appellate division did, you know, find it unpreserved, and there's no question.
Are you saying that they didn't have a right to
Right.
on their own to say we want a hearing on this? Because frankly, when I looked at the record, it's kind of a mess. I was being facetious, but I think you got 3 or 4 ADAs. It seemed like every time this case was coming in, there was another excuse, not necessarily all by the people, but the case, you know, and I'm looking at it now, I mean, it's 10 years this Saturday that this crime happened. And you know, we're arguing this appeal. No one seemed to care about this case, and I just thought maybe the appellate division said there's just too much going on in this case for us to make a determination. We're going to send it back for a hearing.
Well, they have the right to send it back for a hearing if they choose. They have that discretion, and we're not contesting the fact that it was sort of error for them to do so. But we're contesting the defendant's argument that because it was sent back for the hearing, that somehow this unpreserved claim on the merits somehow became preserved.
Well, what could the hearing have been about, in your view?
The hearing was to allow us to develop the facts of our 3034G exclusion, which we did. We showed that obviously he didn't go to Egypt, but went to Yemen with the coming back via a couple of southern states, and it also developed, you know, what contacts we had before he left. But otherwise, the defendant never challenged us on the facts, never said that, well, the complainant was never, he was out of the country, he was always in town and available. He never contested that on the facts or contested the fact that the prosecutor reached out to him. He only challenged it on the law, which is what he did in his initial brief in the appellate division, and which he failed to do and was perfectly in position to do in the trial court. And therefore, like I say, under the Beasley-Loop-Round rule, he failed to preserve the merits of his 30-30 claim.
But it's not the facts in this case, and don't take offense, but let's assume in the hearing, the judge found that there was prosecutorial misconduct, that the people had misrepresented the facts with respect to why this case is there. You would still be making the argument, even though there was prosecutorial misconduct, even though there was a finding by the court on that, we can't consider that because there never should have been a hearing.
No,
That it was unpreserved within the context.
well, we're not arguing that there sort of never should have been a hearing because, as we say, the appellate division has the discretion, if it wants to send it back. And they exercise that discretion here. We're saying that you cannot preserve a claim in a hearing on remittal that you didn't preserve before. I mean, if there had been a new matter, that might have been a different case. But there were no new matters brought up. All we did was show the facts that we had alleged originally in the trial court, and the defendant made his, again, didn't contest those facts, but just made the legal arguments that he raised for the first time on appeal. If I just may point out, it's just too late in this kind of a hearing to preserve. If you look at, for example, CPL Section 330.30 sub 1, that allows a trial court to reverse on a claim which after the verdict but before the sentence on any kind of a claim that would, as a matter of law, require reversal on appeal. In other words, it can reverse on a claim that would be preserved. Well, but this court has held over and over again that if you raise a claim for the first time in a 330.30 motion, it's too late. Now, if it's too late to raise a claim for the first time in a 330.30 motion, it's certainly too late to raise it for the first time on a hearing on remittal after a case is already on appeal. So the defendant here did not suddenly preserve his claim just because it was sent back for a hearing. If there are no further questions, I ask that you reverse it and send it back to the appellate division so they can choose to consider it in the interest of justice. Thank you.
Thank you, sir.